Dear students, ladies and gentlemen, today too I will be talking about formation of company. But just to remind you yesterday's lesson, I would let you again know in a very simple word what the company is. Uh, a company is association of people for trade purpose for a business through which they can earn profit. But the main difference, as I told you, between you see in both the cases, whether this is partnership or company, people invest money for profit. But the main difference, as I told you yesterday as well, that company is a distinct personality from its members, from the shareholders. While in the case of partnership, you see, a partnership or firm is not a distinct personality from its members, that is to say, the partners. Okay? So this company is a juristic personality, a legal personality created by created by fiction of law. You see, it's imaginary. It has got no physical existence. So question arises. We have talked yesterday in detail that how this juristic personality, newly born baby, will arrange capital. We have talked about it in sufficient details. Now, if one question may arise in your mind that, sir, if it has got no physical existence, if it is in the eye and opinion of law only a person having rights and liabilities like a natural person, then who would actually help this juristic personality to, to run the business? For that purpose, yesterday I told you, but not with details, that few of shareholders, they are elected as directors. And directors, they are actually the agents of the company. And they run the business according to the document you see uh, presented to the Security and Exchange Commission of Pakistan, particularly the Memorandum of Association and Articles of Association. So they work for the company, they work on behalf of the company. They are the ones who are actually running the business. Okay? But there are restrictions upon the directors. If they are within the authority given to them by the Articles of Association, Memorandum of Association, well and good. But if they are outside the authority given to them, if they abuse their authority, so they are called to be ultra violence. I mean, they are beyond the. Then the acts would be attributed to them, not to the company. Okay. So yesterday we left our discussion, you see, on the memorandum of association. We talked about memorandum of association, what is its nature, what are the contents, or what are the, you see, uh, clauses, they call it clauses of the memorandum of association. We talked about it with sufficient detail yesterday. Now, today I'm going to start my lesson with the effect of memorandum of association. You know that memorandum of association is prepared by few persons who are called promoters. And they, after you see, preparing or getting prepared a memorandum of association, I'm saying getting prepared because everybody cannot draft a memorandum of association of a company. There are specialized people, lawyers, who draft this important document, and it's very, very essential to draft it very carefully and skillfully. That's why people, you see, contact the lawyers who are in this practice. So they have to be very careful. Why? Because this is going to be our. Yes, I was telling you that one of the essential requirements of validity of a memorandum of association is that it must have been subscribed by few people. The promoters who are interested, the promoters who are, they are the one who conceive the idea of having a company. You see, they are required, either all of them or few of them, they are required to sign it. And this signature is called subscription. They are subscribers to the memorandum of association. And most probably all of them or a majority of them are going to function as directors of the company. So apparently, if you look at the situation, the memorandum of association is signed by few people, 4 or 5 people. And legally, it should be a contract between the company and those who have subscribed to the memorandum of association, those who have signed the memorandum of association. But section 17 says that no, this would be, and it should be binding. It should be binding. You see, the terms and conditions mentioned in the memorandum of association should be binding only and only upon those who have subscribed to it, who have signed it, that is to say, the promoters. But section 17 says that it's not only binding upon them, it is going to be binding upon everyone who later on, after the registration of the company, after the creation of the company, you see, he becomes a shareholder. So he cannot deny his liability by saying that he hasn't signed the memorandum of association. Section 17, you see, is giving us idea about the effect of memorandum and article, both the important documents for the registration of the company. So it says in the first part of section 17 of the Companies Act 2017, you see, it says that a memorandum of association binds all the members of the company. All the members. What does it mean? Initially, there were just 5 members. Just suppose that the company which has been registered, it had 5 people who were promoters and who got the company registered. Later on, there might be thousands of people buying the shares of the company. So the one who buys the share, even if he wasn't one of the subscribers or one of the promoters, this memorandum of association is considered to be a contract between all the common shareholders. So it says that the memorandum and article of association, the section says, shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by each member and contracted a covenant on the part of each member. Is not only each shareholders, but this memorandum of association will be binding upon the legal heirs and legal representatives to be observed and bound by. So whatever terms and conditions, that's why, you see, if someone is interested in buying the shares of the company, he must go through the contents of the memorandum of association before signing the contract, you see, of buying shares. Why? Because this is when not only is binding, this is a contract between a shareholder and the company, and it is not only binding upon him, but his legal heirs. If just suppose a person has bought 100 shares, and he admits the authority of section 17, and he feels that he is binding, I mean, this contract is binding upon him. After his death, you see, his shares are assets, and they can be, you see, inherited by legal heirs. So legal heirs cannot deny that it's not binding upon them. Section has made it very clear that it is binding upon the legal heirs, legal representative. Just suppose that you have traveled abroad and you have given a power of attorney to one of your relatives, friends. You see, you see, to deal with your shares. So he is also, I mean, one of the persons under Section 17 upon whom this contract is binding upon them. Number one. Number two, part number two, I mean, we are talking about the effect of memorandum of association and articles of association. So, effect number two is that whenever a company is registered or whenever you see the subscribers have, these subscribers are going to be the shareholder. If they have paid the price of an, obviously they will be paying the price first. As I told you yesterday that previously under the Companies Act 1913 and under the Companies Ordinance of 1984, it was possible to buy shares on credit. But under the present law, the Companies Act 2017, no share can be allotted until and unless the money, the price is paid in advance in cash. Okay, so there is no possibility that there will be any share. So these people who are the promoters, who are the subscribers to the memorandum of association, they will be paid, whether they are 2 or 10, or you see. So they have to prepare the report of the receipt of payment from the subscribers shall be reported, and this report of payments must be reported to the registrar on a specified form. There is a form available for that within 45 days from the date of incorporation, accompanied by a certificate by a practicing chartered accountant or a cost and management accountant verifying the receipt of the money. So they will prepare a receipt on the prescribed form, you see, and they will submit within 45 days after the registration of the company to the registrar. Number two, this was number two. I mistakenly told you number two. Payment of the price of the share. All money is payable, you see, by a subscriber in pursuance of his undertaking shall be, you see, deposited, shall be debt from the him, and he will be payable in cash within 30 days from the date. He will pay in cash within 30 days. And report of these payments would be submitted to the registrar of company. And fourthly is the consequences of violation. What would be the consequences of violation of Section 17? Section 17 says that the contract is binding upon not only upon the subscribers, but later on coming shareholders, their legal representative, their you see legal heirs, and all the monies deposited by the subscribers that has to be reported to the registrar, etc. If one of the clauses of Section 17 are violated, what would be the consequences? So the last part of Section 17 says that any violation of this section shall be an offense. It is going to be an offense. Okay. So if you remember in the very first section, I told you that the main penal law talking about offenses is Pakistan Penal Code, but Pakistan Penal Code is not the only legislation which deals with offenses. Companies Act also deals with offenses. It says that it is an offense. But in the cases of corporate violation, you see there is no imprisonment. There is penalty of payment of, you see, money as penalty. So if any of the provisions of Section 17 are violated, then there is a penalty prescribed, and the penalty is, it says that any violation of this section shall be an offense liable to a penalty of level 1 on the standard scale. So at the end of the act, there is a schedule of payment. What does level 1 means and what number 2? So for the purpose of Section 17, let me tell you that according to Section 479, 479, the level one penalty is fine up to rupees 25,000. It never says it is fine of rupees 25,000. It says that up to rupees 25,000. It leaves a discretion for the deciding judge. You see, if judge who is looking into the matter of violation, he is of the opinion that only 10,000, 15,000, he has got a discretion, and his discretion starts from rupee 1 to rupees 25,000. And if this money, this amount of penalty is not paid, then there is another further fine, daily fine for the